If you have any concern at all or any interest in insurance, and you probably have because you're paying insurance, whether it's for a car or whether you're an employer, then there's a case they reported last week from the High Court which took my attention. It involved a woman called Eva Ledzinska. She brought a claim against her former employer Lidl. She claimed that she'd suffered a back injury as a consequence of the working conditions in Lidl, and Lidl obviously defended the case and contested liability and basically fought the case. So the case was in the High Court last week. This lady is a 42-year-old woman. She lives in Kildare, but she had a High Court personal injury claim. The injury she claimed to have suffered was a back injury. She claimed it was because of Lidl's working conditions. But it turned out then, when the hearing came on last week in the High Court, that a private investigator hired by Lidl had attended a gym class, and the private investigator got footage of this lady showing her swinging a kettlebell, lifting weights and doing burpees. In other words, the evidence was that the class that she was involved in and the exercise that she engaged in was particularly vigorous and was inconsistent with somebody, quite frankly, having a bad back injury. So when she was being cross-examined, this evidence was put to her, this video evidence, and basically senior counsel for the Lidl was putting it to her that she was making it up, quite frankly, that the back injury couldn't be nearly as bad if it existed at all, and the evidence from the investigator would support that contention. There's two other factors in this case which should be considered and which might make your blood boil, quite frankly. One is that the special damages part of her claim amounted to something like €300,000. The special damages, remember, in a claim like this is simply out-of-pocket expenses. So the likelihood is the special damages would have comprised mainly of loss of earnings. So the special damages part of her claim was for €300,000, and in addition to that then, the general damages part of it would be for the pain and suffering. So if she was successful, she would have been getting 300 grand for special damages, and whatever the judge might decide in respect of the personal injury, the pain and suffering, the general damages aspect of her claim. That's one thing. The second thing is that she managed to persuade the Department of Social Protection that she was entitled to an invalidity pension. So she persuaded the Department of Social Protection, or as counsel said to her in cross-examination, she conned them in relation to the pension, and she got she got a pension for an invalidity pension from the Department of Social Protection. She claimed in the evidence in her cross-examination that she got that on the basis of her MRI scans, which is fair enough, but clearly the private investigator's footage from the gym class gave the lie, quite frankly, to any suggestion that she had actually suffered the injury she claimed to have suffered. It came to the point in the case where the judge, of course, as usual, invited the parties, had a break and invited the parties to have a chat outside. And when they had a chat outside, counsel for the lady in question, the claimant, Eva Ledzinska, he came back in and he said, "It was a very difficult case, Judge, and my client is withdrawing her claim. And not only that, but she's agreeing to make a contribution to Lidl's legal expenses." So there you have it, a woman claiming for a High Court personal injury claim, 300 grand in special damages. Special damages, remember, is only out-of-pocket expenses. General damages then is the pain and suffering, so you're looking at perhaps a significant amount of money there as well, and she ends up, without a backward glance, withdrawing her claim when the footage is put to her from her gym class showing her engaged in very vigorous activity. And as I say, Lidl had hired a private investigator who got this footage. She was shown running on the spot, swinging a kettlebell, lifting weights and doing burpees in a half-hour exercise session. It was put to her that this was rigorous training. She said, "For me, it is stretching and cardio." She's 42 years of age, lives in Kildare. She'd sued her former employer, Lidl Ireland, for this back injury, severe back injury she claimed to have sustained in the workplace. She claimed it began in 2021 when she lifted a 25 kg box as she prepared the special offers aisle. Her claim included a special damages claim of 300 grand. She has not worked since, and she told the judge that she's now on invalidity pension and said she has pain, problems moving and wakes for 2 to 3 hours every night. On the second day of the hearing, Miss Lidzinska was shown to the court, shown the video rather, and the counsel put it to her, "You didn't tell the judge about this, it's very far away from gentle Pilates," counsel said. He said that she'd portrayed herself as a woman who was struggling with a disability and who couldn't walk for more than 10 minutes, and here she was doing intense, vigorous training. She said, "I've 2 legs and 2 arms and I'm not in a wheelchair, I still have pain." She agreed it was not gentle Pilates. Counsel put it to her that she had allegedly conned the Department of Social Protection and you should not be on an invalidity pension no more than the man on the moon. Miss Lidzinska replied that to get her invalidity pension she had to send in her MRI scan results. I presume that the Department of Social Protection will be looking at that particular grant, that particular pension. At this stage, Mr. Justice Michael P. O'Higgins intervened and he said that he would adjourn for a short time as there were issues to be discussed between the parties. He advised Ms. Lidzinska to listen to her legal advisors. When the court resumed, senior counsel for her, Michael Byrne, told the judge it had been a difficult case and that his client was now withdrawing her claim. She had also agreed that she would make a contribution to Lidl's legal costs. And Lidl's legal costs would be significant because this is day 2 of a High Court hearing, and High Court hearings are not cheap. You're looking at junior counsel, senior counsel, solicitors. So that's it. I am sure you will be angry, I suppose, especially if you pay insurance and if you're an employer and you have a hefty employer's liability premium to pay in your policy. Well, then this certainly won't appease you. Hope you find the video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my channel. If you are, hit the subscribe button if you're not already subscribed, and tell some others, if you don't mind, 3 to 5 other people. If you want to do a favour, tell some others or share the channel with them. Thanks a lot.